Hello, good morning, hello, good evening, everyone, and welcome. Whoopsie, of course. Sorry about that. I had set time for 1 minute before I could start, so now you have the behind the scenes. Welcome to the weekly webinar series organized by the Program on Democracy and the Internet, PDI, at Stanford's Cyber Policy Center. Webinar organized in collaboration with the William and Flora Hewlett Foundation Cyber Initiative. This is sadly the last webinar of this academic year, but the webinars have been taking place every Tuesday from 12 p.m. to 1 p.m. PST over Zoom. And we thank you all for your fidelity and presence every week. My name is Julia Wano. I am the Executive Director of the Content Policy and Society Lab, a project of the Program on Democracy and the Internet at the Cyber Policy Center. I am pleased to welcome today in the webinar series two very distinguished guests, Susan Ness, who is a distinguished fellow at the Annenberg Public Policy Center, and Paul Barrett, the Deputy Director and Senior Research Scholar at the Center for Business and Human Rights at New York University's School of Business. Thank you to both of you for this conversation on FTC's role in regulating and overseeing social media platforms. So before we dive into the discussion, I wanted to give a quick reminder of the program for today. We will first start with a discussion with Paul and with Suzanne on this very subject of FTC's role in social media regulation, and then for roughly 35, 40 minutes, and then we will give you the possibility of asking questions. You can, for that, use the Q&A feature that you see at the bottom of your screen here. Then we will, I think we'll have a bit more time for Q&As today because we won't have to announce another webinar next week. So let's start. But before we dive into the subject, I wanted to give you a quick readout of our guests' bios. I will start with you, Suzanne. You're a distinguished fellow at the Annenberg Public Policy Center, where you lead a project to encourage transatlantic governments and stakeholders to forge common modular solutions that are accepted under different tech regulatory frameworks. Previously, you convened the Transatlantic High-Level Working Group on Content Moderation and Freedom of Expression, which published a report and 14 briefing papers. We will share the links in the chat during the conversation. You're also a distinguished fellow at the German Marshall Fund, working on transatlantic digital policy. You are also a former member of the Federal Communications Commission, another regulator. That's going to be a very interesting conversation here, where you focused on digital transformation of communications. You are a board member of media company Tegna Inc. and Vital Voices Global Partnership, which is an NGO that supports women leaders who are improving the world. Now, welcome, Susan. Now, Paul Barrett, you are the Deputy Director and Senior Research Scholar at the Center for Business and Human Rights at the New York University Stern School of Business. You joined the center in September 2017 after working for more than 3 decades as a journalist, focusing on the intersection of business, law, and society. At Bloomberg Businessweek magazine, you wrote cover stories on topics such as energy and the environment, military procurement, and the civilian firearm industry. From 1986 to 2005, you wrote for the Wall Street Journal, serving for part of that time as the newspaper's Supreme Court correspondent. You are also the author of nonfiction books, including Glock, The Rise of America's Gun, and a New York Times bestseller. At the Center for Business and Human Rights, you have written a series of reports on the role of social media industry in our democracy. Topics have included the problems of foreign and domestic disinformation, the consequences of outsourcing content moderation, the debate over Section 230, very, very central at the CPC. We've had very interesting sessions on that. The role of social media in intensifying political polarization in the US and how Congress could enhance the FTC's Federal Trade Commission's Consumer Protection Authority to regulate major platform. You've served since 2008 as an adjunct professor at the NYU School of Law, where you co-teach a seminar called Law, Economics, and Journalism. Welcome, Paul. We will start the conversation with you, and specifically with focusing on your recently published white paper on which is entitled, to be precise, Enhancing the FTC's Consumer Protection Authority to Regulate Social Media Companies. That is a very interesting. I've read the white paper, and I found it extremely instructive, especially for someone who is getting more familiar with the regulatory environment in the United States. So my first question to you, which is quite general, why do we need to have government regulation of the social media industry in the first place? And I'm asking this as someone who is sitting on a self-regulatory initiative, which is the Oversight Board. So very interested in your answer there.
Right. Well, thank you very much. Thank you for the very nice introduction. I wouldn't have given you all that information if I realized you were going to read it all out loud. But in any event, I appreciate it. Yeah, I think your reference to your work with the Facebook Oversight Board is a great place to start. That institution, of course, is a self-regulatory experiment, and one I think is very interesting and important. And frankly, I think in an ideal world, we would rely on the companies to self-regulate. That would avoid entirely the complications of the First Amendment and concerns about government interference with free speech. But unfortunately, I think as the work of the Facebook Oversight Board at least implies, if it doesn't say so explicitly, we're not satisfied collectively with the self-regulatory efforts of the companies. If they were doing enough, you wouldn't need an oversight board at Facebook, or the oversight board would be a lot happier in its rulings and wouldn't have anything critical to say. But there's a lot critical to say. I think there's all kinds of evidence that the platforms are not doing enough to police harmful content, whether that is hate speech or it is mis and disinformation that undermines important public health initiatives, or a whole range of types of problematic content seen all around the world. We found out after January 6th that Facebook groups had been used to help organize the insurrection at the Capitol. In a paper that I'm going to put out with Justin Hendricks next week about YouTube, we catalog the many ways that YouTube is still used as a conduit for mis and disinformation, critically not just in the United States, but in places like Brazil, India, the Philippines, and so forth. And a final thought on this is that the Facebook whistleblower, Frances Haugen, brought forth a huge amount of information showing that Facebook, for one, has considered all kinds of self-regulatory efforts and then set them aside or minimized them because they prioritized other concerns, such as making sure that engagement levels are high. And Frances Haugen had an interesting comment when she testified in late 2021 before Congress. And she said the current regulatory situation resembles, she said, quote, the Department of Transportation regulating cars by watching them drive down the highway. I think that's very much the situation we have now. You have this big influential industry, and there isn't a part of the government that systematically keeps track of it. So those are my reasons why we need to pay attention to this.
Thank you very much. Suzanne, quick reaction to Paul's report and proposal here as a former member of the FCC.
Okay. Thank you. First of all, hi, Julie and Paul. Thank you so much for inviting me to participate today. It sounds like it's going to be a fun panel. I also want to mention that the two projects, the one that I'm working on now in modularity and the other one, both of which are posted in the chat, are part of the Annenberg Public Policy Center at the University of Pennsylvania. I agree with Paul's general recommendation for Congress to grant FCC greater authority over platform behavior with commensurate human resources and funding. He is spot on that is the best place within the US government for that sort of activity. The FTC, the Federal Trade Commission, already has expertise in online privacy and competition enforcement. And these pieces work together. It also gives them some leavening because they can see and compare with other vertical industries to know what's happening in the outside world as well. And I think that that's a useful thing. The focus on procedural, not substantive content regulation, absolutely, way to go. I caution though, when going after online harms that are odious but not illegal, that could cause platforms to over-remove legal content, notwithstanding references to protecting First Amendment rights. And yes, platforms have in fact contributed to the demise of facts-based information, but we need to remember that when today's platforms were still in their founders' dreams or in digital diapers, Fox, talk radio, popular broadcast, cable channels were widely spewing conspiracy theories and disinformation, and they continue to do so today. Can we do anything about that? No, we do not have the truth police in the United States, and I'm glad we don't. People often argue that the same rules should apply online as offline. The FCC does not regulate content except for obscenity. The FCC does regulate political advertising, but simply to require stations to provide lowest unit rate, equal opportunities to place ads, reasonable access, but it cannot edit the content of the ads as long as the ad has the voice or image of the candidate in the ad and is sponsored by the candidate. They can reject ads, stations can reject ads, however, if it is on a website, for example, the station's website. So there's a difference between broadcast and online regulation for things such as even advertising. Some of the disclosures Paul recommends could have unintended consequences. Too much publicly disclosed information on how the algorithm functions risks enabling malicious users to get around systems. An example, which is not quite on point, would be data voids, where very astute malicious users abuse the system by creating a whole set of disinformation because there's nothing to counter it in the calculations. But there, even Paul admirably recommends tiered disclosures, different types of information to public, research, independent auditors, regulators. So that's an important point to keep in mind, that there are ways to mitigate some of the problems as well. And I'm happy to continue or wait with some areas that I disagree with. Up to you, Julie.
No, thank you very much, Suzanne. I think that perspective, especially the, transatlantic and global perspective, is extremely important because, as you rightly mentioned, there are unintended consequences that should be considered, especially with the fact that the United States usually sets the tone in terms of, in many areas, including in regulatory areas. But we'll dive into that later on, Suzanne. I'd like to go back to Paul, maybe to give you an opportunity to explain why the consumer protection law approach and not, let's say, like in the European Union, for instance, which we just mentioned, there will be, with the Digital Services Act, for instance, ad hoc regulators. So why not this approach? and why the consumer protection law approach?
Right. Well, I mean, the place to begin there is with one of Susan's observations, which is that the FTC is already there. The FTC has been regulating, protecting consumer interests since the early 20th century. So, in one sense, there, we have some mechanisms that are already set up and some legal precedents that would be valuable. Which is not to say all this is sort of self-operative. Traditional ideas of consumer protection would have to be updated to fit the information economy and particularly social media companies. And that's part of the reason why we need Congress to act so that the FTC has guidance and a sense of initiative. But I think that another approach to answering the question is to look at what consumer protection law is in the United States. Very broadly speaking, the FTC Act of 1914 forbids unfair and deceptive acts in commerce. And I think the kinds of problems that we have with social media companies fit, roughly speaking, into those concepts, unfair and deceptive. So very quickly, unfairness describes practices that cause or are likely to cause substantial injury to consumers, which is not reasonably avoidable by consumers themselves and not outweighed by countervailing benefits to consumers or to competition. So the important idea is that there has to be substantial injury, and then it's not outweighed by benefits. On the deceptive side, deceptive acts constitute material representations, omissions, or practices that is likely to mislead a consumer acting reasonably in the circumstances. So I think the broad outline here, would be useful to regulators if they were instructed by Congress, authorized by Congress, to basically hold social media companies to the promises that they're already making. This is not an exercise in setting policies that the companies would have to enforce. It would be saying to them that they need to clarify and make clear how they're going to enforce the policies that they're already imposing. And I think it is valuable to look to the FTC to do this and consumer protection concepts, because the agency has already been approaching this in connection with other industries. For example, the agency has brought numerous cases in recent years against a variety of companies that make promises about the protection they will give to their customers' data. So basically cyber protection policies. And in numerous cases, it has been determined that companies have not fulfilled those promises, and that can be determined because people have their credit card information stolen and it turns up in the possession of Russian gangs or others. And those cases have been brought by the FTC and upheld by the federal courts. And I think they provide a rough analogy to what the FTC could do in connection with social media companies, which, as I said, have made in their terms of service or their user standards, community standards, a large number of promises that they say they're already enforcing upon. But the question is whether they're actually doing that effectively, whether they're devoting the resources they need to that in terms of human moderation and as well as automated moderation. So for those reasons, I think the consumer protection mechanism is already there. It provides a way to get at this without telling the companies what their policies ought to be, let alone making substantive decisions for the companies, and therefore ought to be a way to steer clear of First Amendment problems, which should be taken very seriously.
Thank you very much, Paul. I would like to make sure we have enough time to dive deeper into your report. So maybe you can tell us precisely, what do you think the FTC should do? What are your proposals concretely in that report?
Okay, they break down into two broad categories. Transparency or disclosure is the first, and the second is the requiring of procedurally adequate content moderation. Transparency is where you need to start, because without more information, neither the FTC nor anybody else is going to be able to do very much that's effective by way of regulation. So I think that companies can be required to disclose more information about how their algorithms rank, recommend, and remove content. For example, to provide a sense of as to what criteria are used by their automated systems to decide which content goes where and who sees it. We talk a lot about the problematic notion that engagement is highly prioritized by these companies. Well, to what degree is it prioritized? What are, say, the 10 or 15 other criteria that are in the mix? How are they weighed one against the other? So that we'd have a sense as to what might be causing the perceived problems of harmful content going viral and being seen by many, many people. A second aspect of transparency would be to provide more meaningful statistics about effectiveness. Right now, the major companies all have disclosure policies where they provide either quarterly or a little bit less often aggregate numbers on content they take down and so forth. But for the most part, those numbers are not really very helpful. They tend to provide the numerator of a fraction without the denominator, meaning the universe out of which the numbers of takedowns occurs. And this leads to, I think, a situation where people are actually misled as to the effectiveness that the companies are currently have in place. And a good example of that is a statistic that Facebook has trumpeted in many forums that it takes down 95% of hate speech automatically before anybody sees it. And the problem is, people, if you read very closely, Facebook says what that 95% applies to. And it's actually 95% of the hate speech the company takes down is taken down automatically. That gives you no sense whatsoever how much hate speech is actually, what the proportion is. Because the denominator is simply absent. We don't know the larger universe. Moreover, Haugen, in her release of Facebook documents, one of those documents had Facebook people discussing internally that actually the automated systems are only taking down 3% to 5% of hate speech. Now, you'd need more information as to what exactly they were talking about, but certainly 3% to 5% is a lot different from 95%. And in there, I think, is the space where we need to have more transparency. And I think others have written about this very effectively. Karen Hornblue and Ellen Goodman have written about how all kinds of industries have disclosure requirements that require them to provide data to show that safety efforts they're making are working, that they're mitigating harm, and that they're complying with promises they've made. So I think those same types of obligations can fairly be applied to social media companies. So that's transparency. Procedurally adequate content moderation is not the government dictating what the companies take down, but instead saying that if you're going to have a content moderation policy, it has to be clearly articulated. Your enforcement has to be clearly articulated. There have to be effective mechanisms for appeal. And you have to have the resources behind all this to make that content moderation meaningful. And in that regard, I think one question that regulators ought to explore is whether the current approach to human moderation, which is done by means primarily of outsourcing, the social media companies do not themselves even employ the vast majority of content moderators. They hire outside firms who then hire employees. And I think there's a lot of room for questioning whether that leads to effective content moderation, apart from the important questions of what kinds of psychological effects it has on the people who are doing the work. So again, all the emphasis should be on procedural, not talking about the government making substantive decisions about particular pieces of content.
Thank you very much, Paul, for these precisions. So my question here, and that's going to be my last before I go to Susan, how does this coexist? First of all, because a lot of what you said, to be very frank, have been said in various Meta Oversight board decisions, for instance, procedures that are transparent and clear, and more transparency on government requests for content takedown, for instance. We've had a decision that did mention that. So how does this coexist with existing initiatives or pending legislations that are at the Congress at the moment? I'm thinking, for instance, about transparency disclosure, which you mentioned. There is a Platform Accountability and Transparency Act that's pending right now at the Congress. So yes, how does this coexist?
Well, first of all, I make no claim to any of this being entirely unique, and I think pointing to things at the Oversight Board at Facebook, a group of very accomplished people, yourself included, coming to thematically similar conclusions is good news, not bad news. The problem is making something happen. And it's fine for Facebook to have an oversight board that's telling Facebook, the company, what to do. Terrific. But what about everybody else? And what about, is Facebook actually going to do what the oversight board tells them to do or suggests that they do? Meanwhile, in the welter of legislation that's pending in Congress, you have a variety of bills, many of them very worthy. You mentioned a couple of them, but it's far from clear whether any one of those would be kind of a comprehensive approach. So what I've tried to do is articulate some of the general principles that are almost a guide to help you go through the thicket of legislation in Washington. And I think the approach that I outline in the paper kind of pulls together ideas, many of which I source directly to particular pieces of legislation, and brings them together in one place with a kind of an argument behind it as to why this is the way to proceed. And I do all that recognizing that what I'm proposing is more ambitious than any one of those bills. And there's not a lot of optimism, I'll conclude by saying, that any of that legislation is going to pass anytime soon, unfortunately. The very hyper polarization that the social media companies have exacerbated, sad to say, is so deeply embedded in Congress at the moment that they probably don't have the capability to address it. But that's a larger issue.
Thank you very much, Paul, for this amazing deep dive into your white paper, which we have shared the link to in the chat, and we will do that again in a few moments. Now, Susan, I'm really glad that Paul ended on the current polarization. But if we were to talk about polarization globally, there is even more. There are different tensions happening at a global level on this infrastructure that the internet is and how it should be governed. You recently published an op-ed in The Hill, and we'll also make sure to share the link in a few moments, called "A Safe Open Internet with Transatlantic Rules is Easier Said than Done." So you've come with a proposal on modularity as a construct for achieving cross-border alignment on very specific discrete tasks, codes of conduct, accountability mechanism. Can you please explain to the audience what you're proposing?
I'm happy to do so. Thank you, Julie. On both sides of the Atlantic, users face the same issues of disinformation, online harms amplified by the same platforms. But despite many similar governance ideas percolating, transatlantic cooperation on a comprehensive digital regulatory regime is simply not in the cards, especially given disparities in US and European legal systems, norms, priorities, along with very starkly different timeframes. The DSA, as I'm sure your audience knows, the Digital Services Act will soon be formally adopted. The UK's Online Safety Act is going through its legislative paces and is likely to be adopted early next year. And of course, the US is at the legislative starting gate. Here is one way, and I'm calling it modularity, but one way for transatlantic democracies to collaborate. It's modular approach to achieve cross-border alignment on very specific, discrete tasks, codes of conduct, accountability mechanisms for tech governance, notwithstanding these disparate regulatory frameworks. What is modularity? It's government, civil society, and industry working together to create common codes of conduct, protocols, and systems that regulators would recognize as satisfying provisions under their respective regulatory regimes for digital companies. Each module stands on its own. Think of it kind of as plug and play. Functions that are great candidates for cross-border modular treatment include a single system for vetting researchers and protocols for conditioned access to platform data that protect privacy and corporate trade secrets, vetting procedures, minimum standards and oversight of independent auditors seeking to conduct risk assessments and algorithm impact audits. I think both the European Commission, DSA, as well as the OSA refer to those kinds of audits. Minimum disclosures and archiving rules for political advertising, creating a searchable database, and crisis protocols for emergency actions, such as in times of armed conflict, pandemics, mass shootings, where rapid and coordinated response is needed. These are some of the very good ways of using modular. Again, very discrete items, mostly mechanical, where you're not getting into a lot of the value systems that tend to divide rather than unite.
Okay, well, this sounds very appealing and pretty, I don't want to say easy, but probably less heavy to implement than, say, adopting a new regulation in the United States, for instance, given the current political environment. But there have been attempts to, adopt code of conduct in the past with relative success in terms of accountability mechanism, for instance, and follow-up. So how does this modularity system, ensure that what we have signed together and agreed on together in a multi-stakeholder way, something very dear to the Content Policy and Society Lab, well, how do we ensure that this translates to actual implementation and accountability?
Well, first of all, I agree with you. There have been efforts. A lot of this is an iterative process. I think the regulation has evolved over a period of time, and compliance and understanding on the part of stakeholders, including universities and civil society organizations. This has all progressed over a period of time where we have much better understanding of what's at stake and how things operate. So what I'm trying to do is to say, we're not going to reinvent the wheel. We're going to look to see with multi-stakeholders what systems they've been working on designing that could in fact become a module, and then try to get that adopted as recognized basically by several governments as being consistent with their legislation, so that it's the same. What you give up for a jurisdiction in terms of the perfect type of regulation or the perfect type of code of conduct, you make up for having it be the same. You make up for saving regulators. They're not going to have to draft as many rules. There's greater regulatory certainty. They're not having to comply in little bits and pieces, splinter net fashion across a number of jurisdictions. It engages multi-stakeholders, which I think is vitally important. And they will continue to keep watch. It is an iterative process. If they see something is not working, they can amend it. And then if it gets amended, it would be amended across the board. Protection for governments basically would be sunset provisions, so that after, say, 3 or 4 years, there'd be an evaluation. And if it's not working according to plan, then it doesn't have to be renewed. So there are factors for that. And the ultimate enforcement of the rules would rest with the member states, basically, the countries, because at the end of the day, they have the enforcement tools. But this will bring the communities together. This will provide and encourage more trust. And hopefully it will be done in a faster way than trying to get a multitude of jurisdictions to come up with their respective systems.
Thank you, Suzanne. But aside from the political difficulty that governments may encounter to see regulation pass, nevertheless, we see with the proposal of Paul, for instance, or the others that exist out there, there are authorities that exist that do already have some powers to protect consumers or protect citizens in general. And I think there is a question in the Q&A on that. We will get to it in a few seconds. So I'm really trying to understand, what would be the incentive here for a government to agree to give up to such important, I would say, part of its authority and legitimacy, and agree to such cross-border modular treatment. I mean, I can envision a government like in Russia, for instance, or the US government, or I don't know, France or Cameroon. What would be the incentives beyond just evading the political blocking?
We're not talking about non-democratic governments to begin with. So let's take Russia out of this picture completely. That said, there are provisions within the Digital Services Act and within the UK's Online Safety Act that would in fact allow to be determined that an outside code of conduct or other type of regulation could be substantially complying with the requirement under their legislation. Once again, the benefits for this is having common rules across jurisdictions. And from my perspective, one of the ways to get there is to look more at mechanisms rather than very meaty, difficult issues. So it may not be all types of codes of practice that may be too difficult a hill to climb. But if you're starting with something like, how do you vet researchers? What has to happen in terms of them being able to gain access? Are you better off at the end of the day with a number of jurisdictions enabling the same system so that you have much more access? A researcher doesn't have to go through 3 systems to get approval for vetting. Similarly, are we better off potentially, and again, these are all questions that actual experience will be able to answer, but are we better off having common rules for auditors, the vetting of the auditors, what is required, what is the baseline required, and having a similar system across the board? Now, that having been said, one way of structuring this, and there could be many different ways depending upon the kind of module, but one way of structuring could be to have someone from the National Science Foundation sitting on a panel, together with someone from a comparable organization within the UK, together with somebody from the EU, from Canada, Australia. And that would be the panel that ultimately would make a determination if it goes up to that level. So you can do it where government is still involved, but it is slightly removed. In particular, when it comes to content, the further it is removed from playing a role, I think the better it is for democracy. So there are trade-offs. There's no question there are trade-offs. But if we correctly select what modules to develop, the benefits would outweigh the detriment to a government. And
in your modularity proposals, you did mention at several occasions that there are roles for civil society and academia.
Yes.
Can you be more specific here? I'm sure it's going to interest the audience.
Sure. First of all, not wanting to reinvent the wheel. So take phenomenal work that's been done in so many different places. Some of them working with government, some of them just working with civil society, some of them industry developed, some of them developed with civil society and industry together. Look at where those systems, those mechanisms are in development and select those to be the initial module. Some of them, obviously, you have to make a selection, and that's an issue to be addressed. Who selects and how does it get selected? But then multi-stakeholders would continue to be involved in updating those rules, those mechanisms. I use as an example a US system for oversight of the stock markets. There is an organization, semi-governmental, it's private sector, but overseen by the Securities and Exchange Commission, called FINRA. And it has a board comprised industry members and half of public members, civil society members. And they test and license traders and the like for stocks. That is one mechanism where you have public engagement within a system. But there are many other ways of organizing modules, and it frankly would depend on the type of module that you're organizing.
Fantastic. Thank you very much, Paul and Suzanne. Well, your perspectives have spurred a great conversation in the Q&A section of the Zoom. So I've just posted in the chat. Please don't hesitate to ask your question. There are plenty. So I'll just go ahead and ask two questions each time and let you a few minutes to answer. So thank you for a stimulating webinar. What is the current role of the UN in the creation of regulation policy? If it plays one substantially, what would it look like? Thank you. And also, assuming that Congress passes no law to enhance the FTC's authority, what can and should the FTC do now with its existing authority? Maybe a question for Paul, but also Suzanne, of course, jump in. Thank you.
Who should start?
Yeah, please, Paul, please go ahead.
Okay. Well, on the UN, I'm unaware of any substantial or meaningful regulatory activity coming from the UN, although Susan may know about things I don't. And I think the question of what the FTC could do now is a very good one. And I think the implication of the proposal I've made is that there are things the FTC could be doing now under existing law. For example, it could begin to enforce, tell companies that they are required to actually follow through on promises they're making in their terms of service. And by the way, they need to clarify those terms of service in a way that consumers are actually likely to absorb them and understand the standards that they're already promising that they're enforcing. So I think the FTC could, in theory, begin to make tentative progress. The problem is resources and political, courage. The FTC has been, beaten up for decades now, and is understaffed and underfunded. And I think even with a fairly aggressive chair at the moment in the Biden administration, the agency would probably be hesitant to move on this front under the consumer protection rubric unless Congress gave it the go-ahead, authorized being more aggressive.
Suzanne?
Following up on Paul's answer. First of all, particularly the Republicans on the Hill do not like the Federal Trade Commission at all. And in particular, they do not like its current chair. So that makes it even more difficult to get the funding and the regulatory revisions. We tried in 2009, we tried, I was co-chair of the committee that reviewed the Federal Trade Commission for the incoming administration. And we tried to get APA authority, Administrative Procedure Authority, which is what the Federal Communications Commission has. Well, for rulemaking for the Federal Trade Commission, it is so cumbersome. It's called Magnuson rulemaking, intentionally done so that they wouldn't make rules. So once again, it is very difficult to get things done politically. But I agree with Paul to the extent the Federal Trade Commission can begin to do things, among them workshops, convenings, bringing people together to try to resolve some of these issues where they can. And if privacy legislation passes, and it's unlikely, but it's further along than it's been in the past, privacy will help to some extent mitigate some of the problems that we see with online harms. So those are a couple of things, and privacy would land directly, presumably would land directly at the Federal Trade Commission.
And on the UN, do you see a role for the UN in this space?
I would be uncomfortable, and I say that just as a general matter, simply because I think these rules need to be developed by democracies. And I'm not sure that the UN, well, I know that the UN does not distinguish between democracies and authoritarian governments. It has a wonderful role to play in what it does, but rulemaking would not be it. I know certainly at the ITU, we have, the US government has worked very hard to make sure that it does not get authority to be regulating the rules for the internet. For the very reason that I'm saying that authoritarian governments play a major role there. So I would start small and then expand as you see something works, go through the iteration, improve it, and then expand the number of countries that participate.
Thank you, Suzanne. Next questions. Do you think the first step should be a mandatory brief version of disclosure data policy? I think this question is for Paul. Right now, people don't read or understand the long legal documents. And now to you both, major social media platform and companies are owned by billionaires who have incredible influence and power, lobbying power. How will regulatory authorities be able to regulate social media companies when so much power rests with very few individuals?
Well, on the idea of simplifying, community standards or terms of service, I think that it would be a good kind of baby step to take. I think companies would resist even that, so it might be approached more effectively along the lines of what Susan was suggesting via a workshop, or just kind of publicly airing that issue out, bringing people together and talking about how that could be done voluntarily as opposed to making it a requirement. But that would be a first baby step toward requiring procedurally adequate content moderation. As for the power of billionaires, I mean, that is a problem. The social media companies and other tech companies right now are putting on a fierce lobbying campaign to oppose improvements to the antitrust laws, another sort of avenue of approaching the tech industry and trying to exert some more regulatory control. And they certainly would oppose anything that was done on the consumer protection side. And the answer is you just have to do politics. You have to win elections. You have to work hard and ultimately, persuade lawmakers that they have to resist the campaign donations and the soft money and the dark money and all the rest. So there's no panacea for that. That's called American politics that are sadly, heavily characterized by who's got the money.
Suzanne, on this power of billionaires aspect?
Okay, I would point out that most of the most influential newspapers over the 20th century and including into the 21st century were owned by very powerful families. Hearst, what's his name in Australia?
Murdoch.
Murdoch, thank you. The Murdoch family, etc. So this is not, and in Europe, the same thing. There are major news conglomerates that are owned by families or individuals, heavily controlled by those. So this is not a new concept. So apart from that, one other thing that I did want to mention, as much as I like Paul's idea very much about the Federal Trade Commission, the one other caveat is that to the extent you hammer a company for failing to adequately enforce and conduct itself consistent with its terms of service, you're going to encourage them to make a very minimal terms of service so that they don't get hit. And there are lots of companies that are out there that are looking to be the so-called free speech social media companies, where they don't want to edit out all of the and moderate. They would presumably escape regulation because they don't have anything except very minimal requirements in their terms of service. So there are a couple of issues that need to be addressed as we look at moving forward with the Federal Trade Commission and the Section 5 authority.
There is a question specifically on that about the role of the FCC, which already prohibits broadcasting false information that cause substantial public harm. So is there any hope to extend this ban, in your opinion, as part of a new regulation to private entities, including social media companies and cable broadcasters, for instance? And there is another question on, could you talk about the soft law realities, for instance, enforcement signals, to how the FTC engage with platforms? And is there truly room for civil society to influence this? And I'll ask one last question. Do you believe a Brussels effect will speed up the iterative regulatory process in the United States? I think these questions can be addressed to both of you. So one on the FCC extending the public harm doctrine, and then talking about soft law realities that exist and the role of civil society there at the FTC and FCC, and whether or not a Brussels effect can speed up things in the United States.
Well, Susan should talk about the FCC. She's the expert.
Okay, when it comes to anything to do with content, the FCC, the Federal Communications Commission, really does not play a role, as I mentioned before, except in cases of obscenity where they are required to eliminate it. They do not regulate the internet. As long as the current administration is in place, both Republicans and Democrats serving on the Federal Communications Commission do not wish to regulate the internet. So I'm not sure how that would apply to the Federal Communications Commission. With respect to the question of speeding up things, we, by virtue of Europe moving ahead in rapid pace, we have the TTC, the Trade and Technology Council between the EU and the US. They have basically said offhandedly that now that the European Commission has acted on the DSA, it's a been there, done that situation. There's no reason for them to be getting together on anything there. Let's look forward at what can be done with AI and other kinds of newer issues involving tech companies. That said, I pushed back against that by saying there's a ton of things that can be done between the US and the EU, and that goes to the modularity concept. All of the implementation rules, which have yet to be drafted at the European Commission, those could in fact be done on a more transatlantic basis, as opposed to simply having a meeting and saying, well, US government, what do you think? I would much rather it be a more communal, a more cooperative effort there.
Paul, do you want to jump in on the soft law realities that currently exist at the FTC level, and you're aware of any, and whether civil society could play a role?
Yeah. If the FTC wanted to expend some political capital and actual, funding to, set up some type of process where they brought in civil society people and talked about, principles that the industry could embrace voluntarily, that might make some progress, but probably not too much, for the very reason that the billionaires question implies, that the companies are probably not going to give much away unless they're forced to. As to the DSA, it, of course, in a better world, the DSA ought to do a lot of work for the United States. The companies ought to get in line with that, understand that this is for everybody's good, and in complying with the DSA, they would change their behavior globally. Will that happen? I don't think so, but maybe they'll surprise me. All of this, I think, points to another very big point, which is, at least in the United States, the government is not going to solve these problems. The ideas that Susan has articulated, that I've proposed, are not anywhere close to a panacea. The government in this country does not have that much room to maneuver because of the First Amendment, nor should it. Promoting free speech is very important. A lot of what we're talking about is designed to be an incentive for more industry self-regulation. In the end, the industry is going to have to act for its own good and for the good of its users and society at large. This is not a situation where it can be forced. So it's a very tricky area of public policy.
So we have 2 minutes for two great questions and short answers. So to Paul, algorithms have complex effects that even few are able to understand. Would we even know what we're looking at if we were given access under the hood? That's for you, and to Suzanne, maybe to end up on this. Are there any successes in other industries with the modularity model that could be interesting to highlight here? Thank you.
Yeah, I wouldn't know what to look for under the hood, but I think there are computer scientists and others who would, and the only way to find out is to give it a try. Proceeding in the dark doesn't make sense for users or for society at large.
And other areas that have worked, these are all works in progress. For example, GIF-CT is one that was set up to address violence online and terrorism. It's had its problems, but little by little, it has improved its processes working with a number of countries, democracies around the globe. So one could look at that as one example. And we are now beginning to look for other examples in other industries that we can use as models to go forward. One that might be appropriate would be the international accounting standards, which are recognized by a wide swath of countries because of the benefit of having them be the same.
Thank you very much to our guests, Suzanne Ness and Paul Barrett, for a very, very interesting conversation. We still have questions coming in. I apologize, we were not able to cover them all, but please read Paul Barrett's work as well as Susan Ness's work. And like I said, this was the last session of the academic year. So yes, come back in fall for the new webinar or seminar series, maybe in person, I don't know, at least the new series. So thanks all for joining and have a wonderful rest of your days. Thanks again, Suzanne and Paul.
Thank you.